Hello, and welcome to this Company Law MCQs session where we're going to be practicing some MCQs focusing on company law, and that is a private company limited by shares. Before we dive in, I just wanted to cover a couple of things. First of all, why are we focusing on a private company limited by shares? Because that's the focus of the SQE. So the SQE, the broader module is business law. That demands that you have knowledge of sole traders, partnerships, and for partnerships, we also need to have a deeper knowledge of how a partnership operates via partnership agreement and the Partnership Act 1890. You need to have an awareness of and knowledge of the LLP, and you also need to understand the public company and how a private company can re-register as a public company. But the focus of the business law module is on a private company limited by shares. Why? Because that is the main form that is used for operating a business in England and Wales. It's the most popular option. And in addition, it's worth noting that the focus is on advising a small private company limited by shares. So for the SQE, you're expected to reach the standard of a day one solicitor. A day one solicitor is expected to be able to advise a private company on standard day-to-day issues that a private company may encounter. So that can include how to make company decisions, how to raise finance, how to deal with shareholder disputes, how to deal with insolvency. So think about the SQE really as requiring you to have the ability to advise a private company through the whole life cycle of being a private company, from incorporation all through the kinds of issues that a private company may encounter, including insolvency at the end. So that's why in this MCQ session, I'm focusing on private companies limited by shares. The other thing I just wanted to add is the method that we're going to be using to answer these MCQs. And this is all about the MCQ technique that you can and should use when you are studying and revising for the SQE1. So people have different MCQ techniques. One MCQ technique that I know is useful is you read the question line, and often you can actually get to the answer just by reading the question line and the options below without even reading the facts of the MCQ. Now, this technique comes with a warning. You need to be really strong on your legal knowledge. You need to have mastered attention to detail so that you can pick out subtle differences between your 5 options. But if you are really confident in the law and you've found that this technique is working for you once you've reached that stage, it does mean you can deal with MCQs far more quickly. So therefore move on to the next one and deal with the harder ones with more time. But as I say, that technique, bit of a warning notice. What I would suggest is, particularly if you're at an early stage of your SQE journey, is to use what I call the IRAC technique, which is to read through the facts of your MCQ carefully, including, of course, the question line, and then identify, first of all, what the MCQ is testing you on. So the issue behind the MCQ. What that means is, where are you in the syllabus? So the SQE syllabus is vast. There's a lot to cover. It really helps when you're dealing with an MCQ to zone in on the area that you're being tested on. So for the purposes of business law, that might be, for example, the incorporation of a company. It might be the allotment of shares. It might be liquidation. Whatever it might be, we zone in on it. That then allows us to move on to the next stage of the IRAC analysis, which is rule. What is the legal rule that the question is testing us on? And that requires recalling your legal knowledge, bringing it to the front of your mind so that you can then apply it, the next stage, to the facts of the MCQ. The application part means taking that legal rule that you've just recalled, setting it against the facts of your MCQ, and testing whether or not, for example, a legal test has been satisfied, whether an offence has been committed in the context of criminal law, basically what the answer is, really. And then the final stage is, once you've got that framework of what you think the answer should be in your head, you then select between A to E, the one that best fits your framework. Now, one thing to watch out for, because this is single best answer, there might be more than one correct answer. You need to choose the best one. It's why getting a framework in your head as to what you think the answer should be can help with that. If you can then see the answer that best fits with what your analysis has concluded, that means you're more likely to select that best answer. So we're going to be using that technique today as we go through these company law MCQs. But let's dive in and start with the first one, which is a private company limited by shares borrows £500,000 from a bank. As security for the loan, the company grants the bank a fixed charge over one of its machines. The charge is never registered at Company's House within the statutory time limit. 2 years later, the company enters administration. The bank argues that it's entitled to enforce its security. Which of the following best describes the legal position? Okay, so first of all, what is this testing us on? It's testing us on the rules when it comes to a company granting security. What's required when a company grants security? So let's discuss that. Firstly, what's security? It's security granted by a company or an LLP, but for our purposes, a company, to a lender as security for their loan. What that means is, remember, your lender will have lent a principal amount of money. It will charge interest on that money. That interest acts as profit on the amount that it's lent. The lender will therefore receive the full capital amount back plus interest. And that interest is that profit on the amount lent, as I mentioned. The risk for the lender is that the company defaults, goes into insolvency, lender doesn't get their money back, already interest is therefore left out of pocket. To remedy that, so to mitigate against that risk, the lender takes security so that if the company does go into insolvency, the lender can act. They can enforce their security, so they can basically sell their asset, recoup the proceeds, or if it comes down to a liquidation, they may be higher in the order of priority than creditors who don't have security, and that means that the chances of them being repaid are more. Also, security does give you certain rights, so that's rights under statute, could also be rights contained within the security document itself. So security provides protection for your lenders. So that's background in respect of security. What about the processes for the granting of security? So zoning in on a private limited liability company, it's worth understanding that there are no statutory limits, so no limits under the Companies Act, as to how a company grants security and the authority needed. And what that means is that directors under the Companies Act and under the model articles can borrow and grant security as they wish. It must still be in the best interests of the company, and it must be in line with their broader statutory duties under the Companies Act. So best interests of the company as they honestly believe, section 172, but also done in a way that is essentially not negligent, section 174, etc., etc. So limited by those statutory duties, yes, but procedurally, the directors can take out debt, issue security without needing shareholder authorization. Subject to the articles, which may place authorization on the directors, no need to get any shareholder authorization to grant security. Now, that's not a focus of this question, but just bear that in mind. The focus of this question is, once the company has granted security, what's required? What's the next step? And the answer is to register that security at Company's House, and to do so within 21 days from the date of the creation of security. So if a company grants a fixed charge, a floating charge, a mortgage, any kind of security, it must be registered at Company's House from 21 days of the date of creation. That is filling in what's known as Form MR01, paying the registration fee. Your security is then registered, is publicly available for viewing on the register for your company at Company's House, but that's the requirement. That's the requirement under the Companies Act. And really what this question is asking you is, what happens if you fail to do that? So on the facts of this question then, going back to the question itself, security is being given, a fixed charge over a machine, given by a company, but we don't have any registration. Company's gone into administration, and the bank is effectively arguing that because they have a fixed charge, they have a right to be paid out first. So when the administrator comes to selling the assets of the company to have proceeds to then distribute to the creditors, the administrator will pay the fixed charge holders first. They will deduct any cost of sale and cost of dealing with the assets, but they will pay the fixed charge holders first. The problem is that this security has not been registered. Now, what's the effect of that? So if security granted by a company is not registered within that 21-day period, then the security is void against a liquidator, administrator, and any creditor of the company. And therefore, the effect is that the administrator will not pay out the proceeds of any sale of the asset secured by the fixed charge to this bank, so of this machine. Instead, this bank will rank as an unsecured creditor, so will only receive any payment after the payment of your fixed charge creditors, your preferential creditors, your floating charge creditors. So right at the bottom, essentially, of that order of priority. But one thing just to note is that the loan itself is not rendered invalid. So under the Companies Act, the loan actually becomes immediately repayable. So the contract under which the loan is granted, not rendered invalid, still a valid contractual agreement, but actually is immediately repayable, and the security itself is void. So we've applied that to the facts to state that the position will be the bank cannot have any claim to this security. They will rank as an unsecured creditor. It's therefore void against the administrator and other creditors, but the underlying loan is still repayable. And that means that the answer is going to be B. Just note that the other answers are incorrect for various reasons, but C is incorrect because it states that the failure to register extinguishes the obligation to repay the loan. As I've mentioned, the loan obligation remains, but it is now immediately repayable. And it's not a criminal offence to fail to register, as E states that it is. So B is the correct answer here. So within 21 days, beginning with the day after the charge is created, we must register the security granted by a company at Companies House. Failure to do so means that it's void against liquidator, administrator, or creditors of the company. Underlying loan agreement remains outstanding and is immediately repayable. Just a couple of other things to add. This rule also applies to an LLP. So an LLP, remember, registered at Companies House. If an LLP grants any security, like a fixed charge or a floating charge, that must also be registered at Companies House within the same 21-day time period. The other thing to add is that if our company were to grant a legal mortgage over land, so if, for example, they were to grant a legal mortgage over registered freehold title, remember that that legal mortgage is a registrable disposition when granted over registered land, and also when granted over unregistered title is a compulsory first trigger for registration. So what that means is that if we were to grant a legal mortgage over land by way of security, the mortgage itself would be registered at the land registry, but because it's still security granted by a company, it also needs to be registered at Companies House within 21 days. So just bear that in mind. We've got two registration obligations for a company or LLP where security is granted over land. I've also just summarised briefly in a few bullets that position in respect of the requirements to register your security. So deliver the required particulars to Companies House within 21 days. If not registered, void against liquidator, administrator, and creditor, but the underlying loan remains outstanding and immediately repayable. Good. Okay, let's go on to the next question then. A private company limited by shares that uses the model articles has 100 ordinary voting shares, all of which are entitled to vote at a general meeting. All shareholders attend and vote on an ordinary resolution. Exactly 50 shares are voted in favour of the resolution, 50 shares are voted against it. What's the legal effect of the vote? So what this question is demanding of us is really the basic understanding of what resolutions are and what they mean. So, to understand this, let's go right back to the beginning and dissect this question piece by piece. Before we do so, I just want to discuss this model articles point, because it's really important that we understand what these are. So, the model articles for a private company are articles issued by regulations, so statutory instrument, and they are the default articles that apply to a private company. So when you incorporate a private company, you've got three options: to use the model articles, to use the model articles with amendments, or to use a set of bespoke articles. The default is the model articles, so if you don't choose either of those three and you submit your form IN01 online, then the model articles will apply. In reality, the model articles apply to most small private companies. And it's only much larger companies that will have amendments or entirely bespoke articles. So most people who set up private companies will use the model articles. For the purposes of the SQE, what that means for us is that we should have, before we go into this exam, a really good understanding of the model articles. Two reasons for this. One is that they are the rules that operate for most companies, as I mentioned. We need to reach the standard of a day one solicitor. That means basically being able to interpret and apply the model articles, because these are the rules that most solicitors will be reading and applying when they're advising private companies. So that means, because we need to reach a day one solicitor standard, we should have a good understanding of the model articles too. But the second point is that a good understanding of the model articles really enhances your understanding of company law. Once you've had a good read through the model articles, it will give you a much better understanding of the context of the module and the company as a private entity as a whole. And I think that a lot of people struggle with company law because they fail to just take that time to read through the model articles carefully. So my recommendation, my tip is, if you've got the time, have a read through the model articles. You can just find them online. They're really easy to read through. And as you will see, most of the model articles are all about how directors take and make decisions. So directors' decision making on a day-to-day basis. The Companies Act contains no stipulations, so no rules on how directors can make decisions. So that's entirely down to a company in their articles. So again, as I say, reading through the articles gives you a really good understanding of director decision making. So that's the model articles that I just wanted to discuss quickly. Another thing I think that's worth just picking out from this, slightly separately from the MCQ, but worth just going over, shareholder decision making. So when it comes to decision making by shareholders, unless we're using the unanimous consent procedure, known as the duomatic principle, but we're not going to get into that, shareholders take decisions via resolutions. So that's either ordinary resolutions or special resolutions. Those resolutions are taken for a private company either via the written resolution procedure or at a general meeting. Here, we're having the decision taken at a general meeting. Remember that for the purposes of a general meeting, when you're counting the votes of the shareholders, you're counting only the votes of those who are actually present. So out of the shareholders there, do you have the required numbers for an ordinary or a special resolution, as we will soon go over? That means if you don't attend your general meeting, your vote does not count, and you're not counted for the purposes of the decision-making process, which is why you can appoint a proxy to stand in your place. They will be counted as part of the vote in the general meeting, and they'll also vote in accordance with your instructions. So just note that point. When it comes to counting the votes of a general meeting, you count only out of those who are present. Whereas with a written resolution, it is one vote per share, so based on basically a poll vote, out of all your shareholders. Okay, so that's a difference there between the written resolution and the general meeting. The final thing just to say before we dive into the question, I promise you I will dive into the question, is how votes are taken at a general meeting. So with a general meeting, you've got a show of hands vote, which is usually initially taken. So that is literally the shareholders there raising their hands, and you count the votes of those who have raised their hands out of the total, and you check, do we have the required amount for the ordinary or special resolution? The alternative is a poll vote. So that is one vote per share. So if you own more shares, you'll have a greater vote, more voting shares, you'll have a greater vote. And the poll vote is usually demanded after the show of hands vote, demanded by a shareholder or shareholders who represent at least 10% of voting rights out of all the shareholders. But under the model articles, it could also be demanded by any two shareholders or the chair of the general meeting or the directors as well. If the poll vote overrides or disagrees with the show of hands vote, it's the poll vote that wins. So bear that in mind again. As well, not something that we are covering in this MCQ, not something that we're being tested on, but I thought it was worth just going over that groundwork. Is there anything else I think is worth chatting about? Yeah, the chair. So we'll come across more detail on the chair here, but let's just discuss the chair very, very briefly. So we have a chair of a board meeting. So that is a chair of the board meeting of the directors. So when the directors are taking a decision, they can, under the model articles, elect a chair. But we also have, under the model articles, the chair of a general meeting. And again, this can be selected by the directors. It can even be a director. And the chair of the general meeting, like the chair of the board meeting, will run the meeting. But there is a difference between these two that we will talk about soon. Okay, all of that was just groundwork. Let's focus on the question itself. So let's talk about the law here. What is this question on about? So we've got this 50-50 split here. We've got exactly 50 votes in favour and exactly 50 against voting on an ordinary resolution. So what this question is testing you on is what is required for an ordinary resolution. Now, what's required for a special resolution? At least 75% approval. So 75% approval of the shareholders at the general meeting. So 75% by way of show of hands or voting rights of the shareholders who are there. That's required for a special resolution to be passed at a general meeting. Okay. What about an ordinary resolution? So I think this is where a lot of people get tripped up, which is why I've included it as an MCQ. Because a lot of people think, given that the special resolution is at least 75%, I'm going to say that I think the ordinary resolution is at least 50%. So you'll often hear people say we need 50% for an ordinary resolution. That's incorrect. And that's the kind of misunderstanding that could cost you an MCQ. What you need for an ordinary resolution is a simple majority. So that's 50.01% or above. Okay, so basically 51%. You need a simple majority to pass an ordinary resolution. And that means where you do have a 50-50 split as here, the resolution does not pass. Now, this brings me on to the chair point. Again, another confusion point for candidates is that the chair of the board meeting, remember we talked about how in a board resolution, the directors can elect a chair, the chair will run the meeting. They'll also sign the board minutes to confirm that the board minutes accurately record the board meeting and that the board meeting took place. But the other thing that the chair will have under the model articles is a casting vote. So when directors take decisions at the board meeting under the model articles, that's via majority vote. So the directors raise their hands, and if you have a majority of directors, the board resolution passes. But where there's a deadlock, so let's say we have 4 directors, 2 opposed, 2 against, got a deadlock, we don't have a majority, the chair who's been elected at that board meeting has a casting vote. So out of those 4 directors, let's say one of them is the chair. We've got that initial split, 2-2, 2-4-2 against. This is a fictional board resolution scenario. The chair then has that extra casting vote to break the deadlock, and therefore the resolution can pass. Or, of course, they can use their vote the other way and stop the resolution from passing. But the point is that under the model articles, the chair of the board meeting has a casting vote. But that's not the case for a general meeting. The chair of the general meeting does not have a casting vote. Now, usually the chair is a director anyway, so as a director who does not hold any shares, they wouldn't have a vote in the first place. But even if it was a shareholder, there's no concept of the casting vote under the model articles for a general meeting. Now, it might be in another set of articles a company has included a casting vote in the form of, say, a weighted voting right in a general meeting where there is a deadlock. So if your chair is a shareholder on a deadlock, they can have a weighted vote to break that deadlock. That could be something included in a company's articles, but it's not something in the model articles. So again, watch out for that. So what's going to be the best answer on that basis? If we then apply and conclude, we've got a deadlock, we don't have any concept of casting vote, we need a simple majority to pass an ordinary resolution, therefore the best answer is C. Okay, we don't have that simple majority, we don't have the ordinary resolution, there's no casting vote in respect of any chair, and again I've summarised that here. So resolution passed by a simple majority is an ordinary resolution. That means more than 50% of the votes cast. A 50-50 split does not pass an ordinary resolution. We don't have, under the model articles, the concept of a casting vote by a chair of a general meeting, and a special resolution requires at least 75%. Okay, let's go on to the final question then. A private company limited by shares has adopted the model articles, but subsequently amended them to provide that a director may only be removed from office by special resolution of the shareholders. The company has 4 shareholders. At a properly convened general meeting, the shareholders pass an ordinary resolution removing one of the directors from office. More than 50% of the votes cast are in favour of the resolution, but fewer than 75%. The removed director argues that the resolution is ineffective because the company's articles require a special resolution before the director can be removed. Which of the following is the most accurate? So this MCQ is testing us on 2 rules. The first is, what's required to remove a director? And the second is, can the articles, a company's articles of association, can they amend that requirement? So let's deal with the first issue first. What do we need to remove a director? And under the Companies Act, to remove a director, the shareholders need to have passed an ordinary resolution at a general meeting. Now, there are rules about the calling of that general meeting, so usually a director can call it, but if the shareholders representing 5% of voting shares request a general meeting and it's refused by the directors, they can call one themselves. Special notice is required under section 312 of your general meeting. The director also has rights to speak at the general meeting. So there's all of that, and I recommend if you're not familiar with the process to remove a director, have a look through all of that again. But that's not actually the focus of this MCQ. This MCQ is testing us on something slightly more subtle. So we know then that we need an ordinary resolution, remember that simple majority, to be passed at a general meeting to remove a director. The next question is, can that be amended in your Articles of Association? Now, what you can include in your Articles of Association is a right for the board to remove a director. So you can have a right that the other directors, by board resolution, remove one of the directors. But what you can't do is raise that requirement threshold of an ordinary resolution to remove a director to anything higher. So a special resolution or unanimity. And if you try to do that, then that provision is void. It won't be effective. There are other examples of that in company law where an attempt to change something in your articles, so change the underlying rules in the Companies Act, won't work. So another example would be that a private company has, or the shareholders of a private company have the right to make decisions via written resolution. And the articles cannot restrict that. Now, when it comes to removing a director, that must be at a general meeting. But otherwise, the Companies Act requires that shareholders have a general right to use the written resolution procedure if you're a private company. Public companies can't use a written resolution procedure. But if your articles try and restrict the use of written resolutions, it won't work. So there are other examples of where if you try and amend the Companies Act in your Articles of Association, it will simply be void, and this is one of them. But it's worth noting that otherwise, a company does have flexibility when it comes to the running of the company, and that flexibility is contained in the articles. And I've mentioned that the Companies Act contains no provision as to how directors make decisions. That's an example of the massive flexibility that you can give director decision making in your articles of association. But going back to the MCQ then, the director who has purportedly been removed is arguing that it won't be effective given that the articles require that 75% approval. But applying the law to the facts, we know now that we only need that ordinary resolution, and we've got that. The MCQ has told us that the general meeting's been properly convened, that the resolution has passed as an ordinary resolution, so more than 50% of the votes cast are in favour. So we know that we have the ordinary resolution, and we know that we can disregard the director's arguments because that provision attempting to make that higher threshold, that 75%, that will be void. So the director has been validly removed, and that's under Section 168 of the Companies Act 2006. The articles can't impose that higher threshold. Do we need to know it's Section 168? The answer is no. You don't need to know that specific statutory reference, but I've included it here so that you guys can have a look at it yourselves and you've got that full context. But don't worry, you don't need to know that section number for the exam, but you do need to know the underlying rules when it comes to a removal of the director process. So the correct answer is D. Section 168 gives the shareholders a statutory right to remove a director by ordinary resolution, must be passed at a general meeting, and your articles cannot restrict that. They can't require it, for example, to be via written resolution, but they also can't, as we've been tested on here, require it to be higher, so unanimity or special resolution. So in general, we do have flexibility in the articles, but that is subject to some requirements under the Companies Act that cannot be amended, and any attempt to do so makes it void. The other thing just to add, which the answer does mention as well, is that the director has been removed under the processes of the company and company law, but that doesn't prevent the director from seeking remedy privately. So, for example, the director may also be a shareholder. That means they may be party to a shareholders' agreement. That agreement may contain terms about director removal. It may therefore have been breached, and therefore there may be a contractual compensation claim there. Also, their own employment contract as well, so that could have been breached by removing them. So may also be compensation payments there. But for the purposes of company law and whether as a director they've been removed, the answer is yes. Your articles cannot raise that ordinary resolution any higher. It must be via ordinary resolution passed at a general meeting. Again, summarised it here. So under Section 168, the shareholders may remove a director by ordinary resolution at a general meeting. It can't be removed by written resolution. The Companies Act expressly specifies an ordinary resolution is required, so you can't impose that higher voting threshold. So the director has been removed. Good. So just 3 company law questions. Hope you found that helpful. And we will keep practicing MCQs in further videos of different subjects, all the while developing that legal knowledge and refining our MCQ techniques.